Hi, welcome to our channel where we share the most intriguing stories. When a devoted father moves to a quiet suburb to care for his disabled son, he never expects the true battle will be against his own neighborhood. But when the HOA declares war over a medical van, he's forced to fight back with the law, the truth, and everything he's got. I never planned to live in a neighborhood with an HOA. 6 years ago, when my wife's health began to decline, my only concern was proximity to the hospital and whether I could build a wheelchair ramp without jumping through flaming bureaucratic hoops. Willow Hills ticked enough of the boxes: quiet, suburban, decent schools, good road access, and just 10 minutes from her neurologist. The fact that there was a homeowners association was a footnote I barely skimmed. At the time, we had bigger problems, like keeping her alive long enough for our son to remember her. I'm Robert Cameron, 46 years old, widower, father of one. My son Tyler is 12 now. He's got severe cerebral palsy, epilepsy, and a sense of humor so dark it might qualify for a minor felony. He can't walk or talk, but don't think for a second the kid's not sharp. His eyes say what his body can't. Some mornings he rolls them so hard at me I think he might dislocate something. Our house is on a corner lot with a wide driveway and custom concrete ramp that I poured myself the year after we moved in. I designed everything for efficiency. The front door opens to a smooth hallway with no thresholds. His bedroom is downstairs, directly across from the modified bathroom. I even installed a ceiling track lift after nearly wrecking my spine one winter trying to get him into the tub. Every inch of the house is built around making his life a little easier. And mine, by extension. The ambulance arrives every morning at 7:30 sharp. It's not the screaming sirens kind, just a clean, white, unmarked medical van with a hydraulic lift and 2 calm, well-trained drivers. It takes him to outpatient therapy 3 days a week and to school on the other 2, depending on his schedule. Same in the evenings. Drop-off around 4:30. I pay for it out of pocket. My job as an electrician's been steady, and I have a small settlement from my wife's insurance. I don't own a boat. I don't take vacations. I don't buy toys. This is where my money goes. Tyler's movement, Tyler's care, Tyler's life. Until recently, nobody had a problem with the van. Most of the neighbors knew our situation. Some waved when the driver came. A few even offered help on rough weather days. It wasn't exactly a festival of compassion, but at least people minded their own business. That changed when the new HOA board took over. It started with flyers. One was slipped into my mailbox like a piece of smuggled contraband. Community standards matter. Let's restore visual harmony, it declared in bold navy font. Apparently, cluttered curbs were a threat to the aesthetic sanctity of Willow Hills. And the man behind the mission, Richard Drake, newly elected HOA president and former Navy lieutenant. The guy introduced himself to the neighborhood via a 10-minute speech at the park about civic uniformity and the tyranny of visual chaos. I thought he was kidding at first. He wasn't. About a week after the flyers, I got the letter. It was printed on official HOA stationery with a small embossed emblem at the top, some kind of stylized tree with the motto "Tradition through Order." The body of the letter read, "Dear Mr. Cameron, it has come to our attention that a non-residential commercial vehicle parks regularly at your address. Per Section 8, Subsection 3 of the Willow Hills Community Covenant, the regular presence of work-related or medical transport is prohibited in residential driveways. You are hereby required to cease the use of your driveway for this vehicle within 72 hours of this notice. Failure to comply will result in daily fines of $250 and potential legal action under HOA enforcement procedures." I read it 3 times. I checked the envelope to make sure it wasn't some bad prank. Then I read it again, slower. No contact number. No, "We understand your circumstances." Just legalistic garbage and a countdown to punishment. I sat back in my chair, staring at the paper. Tyler was watching cartoons, barely blinking. I looked at him, then at the paper, then at him again. The corners of his mouth were twitching. He'd noticed I was pissed. He doesn't miss much. "Welcome to suburbia, champ," I muttered. That night, after he was asleep, I went into my files. I pulled out the contract with the transport company, the ADA documents, the letter from the clinic verifying the necessity of daily transportation. I scanned them, composed a calm but firm email to the HOA contact address, and attached the documents with a note. This is not a commercial service. This is a medical transport for a disabled minor under doctor's orders. Please confirm receipt and confirm exemption under ADA compliance standards. Thank you. I didn't expect an apology, but I didn't expect what I got either. The next morning, I received a one-line email reply. Your appeal is denied. Your use of the driveway remains in violation. That was it. No explanation, no human contact, just a denial. I sat there stunned. I hadn't even filed an appeal. I was explaining a medical necessity. These people couldn't be serious. They were choosing curb appeal over access to care? I walked outside just in time to see the ambulance pulling up. The driver, Chris, a former EMT with a voice like sandpaper and a soul made of gold, leaned out. Everything okay? He asked. I forced a smile. HOAs got their panties in a twist. Chris snorted. Don't they always? I didn't answer. I watched him load Tyler like he always did. Gently, efficiently, with the kind of quiet respect that makes you want to hug someone. Then I looked back at my mailbox, where the letter still sat, half folded, like a threat whispered through paper. This wasn't over. 3 days after my polite response and their equally polite go to hell, I heard tires on gravel and looked out the front window. The ambulance had just arrived, right on time, and Chris was wheeling Tyler down the ramp in his specialized chair. I was sipping coffee and running through my work schedule in my head when I noticed something off. 2 men in matching polos, navy blue with the Willow Hills HOA logo stitched over the breast, were standing on the sidewalk with their arms crossed. They weren't neighbors. They were enforcers. I opened the front door just as Chris locked the wheels in place at the bottom of the ramp. One of the men, square-jawed with a clipboard, stepped forward like a mall cop itching to detain someone. "Excuse me, sir," he said to Chris. "You can't park here. You'll need to move the vehicle immediately." Chris glanced at me, then back to them. "Medical transport. This address is a contracted pickup point." "You're still in violation of community policy," the clipboard man said, his voice tight. "You've been reported. If you don't move the vehicle, we'll have it towed." Chris straightened up slowly, his hand never leaving the back of Tyler's chair. "You try to tow a van while I'm loading a disabled kid," he said, "and I'll call every news outlet from here to Raleigh before you get the hook on it." The second guy, a wiry man with thinning hair and the dead eyes of a DMV clerk, pulled out his phone and began filming. I stepped down from the porch. "Put the phone away," I said. My son didn't consent to being recorded. He didn't respond, just kept filming. I put myself between the camera and Tyler. Clipboard guy raised his voice, maybe to get it on tape. "You've been warned multiple times, Mr. Cameron. This isn't about discrimination. This is about preserving the visual integrity of our neighborhood." I laughed, loudly. "You think a white van in a driveway is ruining the community aesthetic? You ever looked at Phil's rusted-out pickup on Cloverleaf? The one with 3 flat tires and a busted tailgate? That's being addressed," he said stiffly. "Sure it is," I snapped. "But that's just a truck. This is a lifeline." They didn't care. They turned and walked away without another word, still filming. Chris and I locked eyes, both of us furious, both of us biting back worse things we could have said. "Go ahead," I muttered. "Do what you need. I'll call my lawyer." "You got one?" he asked. "Working on it." He nodded and finished securing Tyler into the van. As they drove off, I stood there fuming in my bathrobe, fists clenched at my sides. That evening, things got uglier. One of my neighbors, Melissa, single mom, 2 kids, drives a Subaru that's always caked in soccer field dirt, knocked on my door with a strange look on her face. She was holding her phone like it had burned her. "Rob," she said, "have you seen the HOA Facebook group today?" "I'm not in it," I said. "They removed me after I corrected the president's grammar last year." She handed me her phone. The page was called Willow Hills Proud, and someone had just posted a video. I didn't even need to press play. I recognized the thumbnail, my house, the ambulance, Tyler, and me, in my robe. The caption read, "Some residents think they're above the rules, even using disability as a shield from community standards. Where do we draw the line?" The comments were worse. "Sad to see someone exploit a child like this for attention. If it's that bad, maybe he should live somewhere with proper medical zoning. This is why we need tighter enforcement. One exception becomes 10. Looks like an abuse of sympathy." My stomach turned. Melissa looked like she wanted to apologize for the whole neighborhood. "I reported the post," she said softly. "But they're not taking it down." I took the phone and rewatched the clip, this time with sound. No narration, just a silent video of me arguing while Chris loaded Tyler, edited to make it look like I was being belligerent for no reason, no context. No voice, just the visual of a guy yelling beside a van with HOA members standing calmly nearby. I handed her the phone back. "Thanks, Mel." She hesitated. "If you want me to say something, I will." "You already did." After she left, I sat down and stared at my own phone. The HOA had declared war. Not with legal filings, not with notices. Those were just the symptoms. The real assault was social. Reputational whisper campaigns disguised as policy enforcement. I opened my laptop and created a new folder, Tyler Defense. Inside it, I dropped everything: transport contracts, medical letters, my ADA exemption documentation. Then I opened my email and began drafting a new message, not to the HOA. This one was going to a lawyer. The next HOA meeting was held in the community center 2 blocks from my house. A beige stucco box with fluorescent lighting, cheap folding chairs, and a faint smell of carpet glue. It wasn't exactly the Coliseum, but as I wheeled Tyler up the ramp and through the door that evening, it felt like we were walking into an arena. People turned as we entered. Some smiled nervously. A few looked away. One woman actually stood up to open the door for us, but no one said a word. Tyler's wheelchair beeped softly as I maneuvered him between chairs. I parked us near the front, close enough to make eye contact with the board, but not so close they could pretend not to see us. Richard Drake was already at the table, flanked by 2 other board members and a younger woman who looked like she regretted her career choices. He wore a navy blazer, khakis, and the same self-righteous scowl I'd seen in military lifers who confuse rank with relevance. As I sat down, he glanced at me, then at Tyler, and then back at his notes. "Let's keep this meeting brief and focused," he said, tapping the gavel on the table like he was presiding over the Supreme Court. I waited through 30 minutes of drainage complaints and lawn violations before he finally reached the point I knew was coming. Item 7. Recurring violations of Section 8, Subsection 3 regarding prohibited commercial vehicle presence at residential properties. Mr. Cameron, you've requested to speak. You have 5 minutes. I stood up. I didn't prepare a speech. I didn't need to. "My name is Robert Cameron. I live on Sycamore and Chestnut. My son Tyler has cerebral palsy and epilepsy. He's 12. He can't walk. He can't speak. He needs regular therapy and care. The van that parks in my driveway twice a day is a licensed medical transport, quiet, unmarked, and necessary. Without it, he can't receive treatment. Without it, I'd have to carry him down a ramp, into a car, into a facility with no lift. You know what happens when I try that? This." I pulled out my phone and held up a photo. Tyler's back, purple and red from a failed manual transfer after the last time the van was late. A few people in the room gasped. I didn't look at them. I was staring straight at Drake. "I've sent you documentation, medical necessity, ADA exemptions. I'm not running a business. I'm not violating anything. I'm just trying to keep my kid alive without being fined for it." I sat down. Tyler looked up at me with calm, unreadable eyes. He was used to watching me fight battles he couldn't see. But this one was in the open. Drake cleared his throat. "Mr. Cameron, we appreciate your emotional testimony, but the board is responsible for upholding the standards of Willow Hills. We cannot make exceptions based on individual circumstances, no matter how tragic. Visual consistency is not negotiable." There was a quiet murmur in the room. One of the board members shifted uncomfortably. The woman beside Drake looked like she wanted to crawl under the table. Another resident, Joe, a retired Army sergeant who I barely knew but had nodded to on dog walks, stood up without being recognized. "This is insane," he said. "This man's kid needs help, and you're handing out fines like he's selling tacos out of the driveway." "That's not appropriate language," Drake snapped. "You know what's not appropriate," Joe shot back. "Telling a disabled child he's bad for curb appeal." Someone else clapped. A few murmured in agreement. Drake banged the gavel again. "This is not a debate," he said. "The board has reviewed the matter. Mr. Cameron has been found in violation. The daily fines will be paused for 7 days pending resolution. After that, $5,000 in penalties will be assessed for continued non-compliance." My ears rang. I looked at Tyler. He blinked once, slowly. Drake stood as if closing a ceremony. That concludes tonight's agenda. As we rolled out, Joe caught up to us. "You need help," he said, "and not the kind that comes with sympathy. the kind that comes with legal teeth. I nodded, already in motion. He patted Tyler on the shoulder gently. Your dad's a good man, kid. Outside, the parking lot was nearly empty. I loaded Tyler into the van myself. Chris had the night off and drove home in silence. The war was no longer private. It was public now, on record, and the clock was ticking. 2 mornings after the HOA meeting, I stood at the kitchen window, watching the street with my second cup of coffee going cold in my hand. 7:30 came and went. No van, no Chris, no backup driver, nothing but wet pavement and the faint sound of a garbage truck somewhere down the block. Tyler was ready, clean, dressed, strapped into his chair, his backpack hanging from the handle. He kept glancing at the front door, then back at me. Like he was asking the question neither of us wanted to answer. I grabbed my phone and called the transport company. After 2 minutes on hold, someone transferred me to dispatch. The voice on the other end sounded uneasy. We had a vehicle assigned to your pickup, she said, but it was impounded this morning. Impounded? I repeated. Yes, sir. According to the driver, it was towed from your driveway by order of the Willow Hills HOA. I nearly dropped the phone. The hell it was. There was no one outside, no notice, no warning. And he was supposed to be in the van. How do you tow a vehicle with a patient in it? Apparently, the driver stepped out to assist with entry, she said. And when he came back outside, the van was already being loaded onto the tow. My stomach twisted. I thanked her, hung up, and turned to Tyler. His face was still. Too still. A kind of stillness I'd learned to dread. Within minutes, his arms started to twitch. His head jerked once, then again. I sprinted to the cabinet for his emergency meds, but I was already too late. He was going into full seizure. I called 911. By the time the paramedics arrived, he was deep in the episode. They loaded him onto a stretcher, oxygen mask already in place, and I rode in the back, holding his hand, praying the lights and sirens wouldn't be the last thing he ever heard. We spent 10 hours at the hospital. The ER doctors stabilized him. His neurologist came down in the afternoon and said it had been close. Another 30 minutes without intervention, and we could have been looking at permanent damage. Or worse. When we finally got home, I carried Tyler in myself. No van, no lift, just me, a worn-out spine, and a level of rage I didn't know I had the capacity to feel. I didn't sleep that night. I stayed up rereading ADA law, looking through emails, compiling timestamps, invoices, any paper trail I could find. At some point, around 4 in the morning, I sent a message through the contact form of a local law office specializing in disability rights. An hour later, I got a reply. K. Johnson Law, Disability and Access Representation, First consultation, free. Urgent matters. Call directly. I didn't hesitate. I dialed. The voice on the other end was calm, crisp, and didn't waste time. Courtney Johnson speaking. I told her everything, start to finish. She didn't interrupt, didn't make pity noises. When I finished, there was a short pause. Your HOA committed multiple federal violations, she said. And if they ordered that tow, knowing what the van was, we're not talking civil infraction. We're talking ADA interference. Possibly criminal liability. I exhaled slowly. I want to bury them, I said. You just hired a gravedigger. She met me the next day in person, 30s, sharp-dressed. Walked like she owned the floor and thought small talk was a waste of bandwidth. She came to my house, reviewed the driveway, took photos, examined the ramp, even asked me to walk her through the morning routine. She documented everything, made notes, and barely blinked when I showed her Tyler's medical reports. Afterward, she opened her tablet. We're going to file on 4 grounds. 1, violation of the Americans with Disabilities Act. 2, intentional obstruction of medical care. 3, discrimination by a governing body. 4, retaliatory enforcement of non-criminal policy. And what happens next? I asked. We sue them, she said, loudly. She also asked for any internal communications I might have received, any emails, screenshots, group posts, anything that might prove motive. HOAs love to talk trash in private, she said. And if I know people like this, they've already made our case for us. I nodded. I'll dig. There's a group page I'm banned from, but some neighbors still have access. Good. Find them. That night, I knocked on Melissa's door. She didn't even wait for me to speak. She handed me her tablet. Already downloaded what you'll need, she said. It's bad. It was. Screenshots, chat logs, names, comments like, he's using the kid to avoid rules. This is why we need stricter enforcement. Medical excuses are the new loophole. If he can't handle the responsibility, maybe he should consider institutional care. I sat down on her porch and stared at the screen for a long time. Melissa handed me a beer. "I'm not proud to live here right now," she said. "Me neither," I replied, "but I'm damn proud to fight back." Courtney didn't waste time. 2 days after our meeting, she filed the first wave of legal documents with the local district court: formal notice of intent to sue, emergency injunction against further interference, and a subpoena request for HOA communications relevant to the tow incident. She sent the paperwork to their legal representative with a cover letter that began, "Pursuant to Title II of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, your client's actions represent clear and repeated violations of federally protected rights. My client is seeking full compensatory damages, punitive action, and injunctive relief." She didn't sugarcoat it. She didn't need to. By the following Monday, the HOA board had lawyered up. Richard Drake had to explain to the neighborhood that they were now officially in litigation. The meeting was closed to the public, but I had eyes and ears on the inside. Joe, my new unlikely ally, texted me afterward. Drake looked like a constipated bulldog. Their lawyer asked if anyone had documentation about the tow. Richard said it was authorized. The lawyer asked by whom. He stammered. It was beautiful. Meanwhile, Courtney and I began assembling the evidence. She reached out to the transport company, which confirmed that the van had been legally parked under a contract with a disabled resident. They provided logs, GPS data, and a notarized statement from the driver describing the tow, down to the make of the truck and the fact that the HOA member on site handed the tow driver a printed authorization form. "Oh, let me guess," Courtney said as she scanned the statement. "That form wasn't from the city." "It wasn't," I replied. "I already asked around. The city confirmed they had no record of a tow request on that date." "Then we've got fraud," she said. "And if Drake forged that form, we'll turn this into a criminal case." That's when things really got interesting. Melissa, bless her fearless soul, managed to pull more screenshots from the HOA's private Facebook group. But this time, someone else reached out to me directly. A man named Leonard, mid-50s, former HOA treasurer who'd stepped down 6 months prior due to ethical concerns. Apparently, those concerns had names and timestamps. We met in a diner off Route 18. He brought a flash drive and a thick envelope. "I kept backups," he said. "Something told me it might come to this." The flash drive contained internal email chains sent from HOA board members using personal addresses. One in particular from Richard Drake was titled Cameron's Situation Strategy. In it, he wrote, "If we keep the pressure on, he'll eventually cave. People like that burn out. Don't let up." No exceptions. Another from the vice president. "The van's a loophole. We can't let that kind of visual pollution become a precedent." And the worst one from a board member I'd never even spoken to. "If his son needs that much care, maybe a residential facility would be better. This isn't a hospital zone." I forwarded all of it to Courtney. She replied 1 hour later with a single line: "They're dead." By the end of the week, she amended the suit to include conspiracy to interfere with federal disability rights, forgery of municipal documents, intentional infliction of emotional distress, discriminatory abuse of governance authority. The news was spreading. Local bloggers picked up the story from court filings. Then a regional outlet ran a headline: HOA accused of discriminating against disabled child in North Carolina suburb. My inbox flooded. Neighbors, strangers, reporters. One woman from a neighboring community offered to pay for Tyler's transport fees. A retired ADA compliance officer volunteered expert testimony. The pressure was building, and Richard Drake, he started to crack. Someone spotted him yelling at another resident in the park about ungrateful traitors. Joe said he tried to censure a board member who questioned the legal costs. Half the HOA emails now came from the board's new attorney, who looked like he regretted ever answering the phone. Courtney began prepping witnesses: Chris, the driver; Melissa, who had documented the Facebook posts; Leonard, with his envelope of secrets; Tyler's pediatrician, who agreed to testify about the medical consequences of missed therapy; and me. Of course, I'd have to testify about all of it. "Are you ready for this?" Courtney asked me one evening. I looked at Tyler, who was sleeping quietly for once. More than I've ever been. The courthouse in downtown Raleigh was a gray rectangular slab with all the charm of a DMV and none of the speed. But as I walked through the metal detector that morning with Courtney by my side and a folder of evidence under my arm, it felt like walking into the ring. Not just for me, for Tyler, for every damn person who'd ever been crushed by policy disguised as justice. It wasn't a criminal trial yet. That was still pending based on the forgery angle, but the civil case had teeth. The courtroom was modest. Oak benches, flags in the corners, a judge with wire-rimmed glasses, and no patience for theatrics. The gallery was more full than I expected. Neighbors, reporters, even a couple of old co-workers from the electrical union. Joe sat in the back, arms crossed, nodding at me once as I passed. Drake was there, of course. Same blazer, same smug posture, but his eyes darted more now, like he was scanning for exits. His lawyer looked like he wanted to be anywhere else. Courtney opened strong. She didn't start with legalese. She started with Tyler. "This is not a case about aesthetics," she said. "It is a case about access. A disabled child had his vital medical care obstructed intentionally by a governing body that prioritized lawn uniformity over human decency." She laid out the timeline step by step. The ambulance, the fines, the Facebook post, the illegal tow, the seizure, the hospital, the forged form. Then she began calling witnesses. Chris went first. Calm, professional, he described the routine, the quiet professionalism of the transport service, the day the van was towed. "They waited until I was inside the house," he said. "I came back out and it was already halfway up the tow ramp." "Was the child already loaded?" Courtney asked. "No, I was inside assisting the father." "Was there any warning? Any citation?" "Nothing, just two guys in HOA polos waving papers." The judge scribbled notes. Next was Melissa. She brought printed screenshots of the Facebook posts, even the one that mocked me for exploiting a child. She read them aloud in a clear voice that shook only once when she got to the one about sending Tyler to an institution. "I'm ashamed," she said, looking at the judge. "Ashamed that people in my community wrote these things, and even more ashamed that it was encouraged." Then came Leonard. He took the stand like a man who had waited 6 months to unload a secret. He confirmed the email threads, explained how Drake had overruled the treasurer's objections, and handed over a signed affidavit stating he'd witnessed Richard order the tow himself. Courtney handed him a printout of the forged authorization form. "Did this document come from the city?" "No." "Do you know who created it?" "I do. Richard Drake." Gasps rippled through the gallery. Drake's attorney objected, but the judge overruled him. Then came Tyler's pediatrician. She explained in calm, clinical detail what happened when a child like Tyler missed therapy. She described the seizure, the hospital stay, the long-term risks. "This wasn't a missed appointment," she said. "It was a medical collapse triggered by denial of care." When I finally took the stand, I didn't read anything. I just talked. I told them about the driveway, the ramp, the decisions we'd made when my wife got sick. The nights I carried Tyler down that ramp by myself, praying I wouldn't drop him. I talked about the fines, the posts, the humiliation. I didn't cry. I didn't shout. But I saw a few eyes in the gallery mist over when I described Tyler's face that morning. The confusion, the quiet fear as he waited for a van that never came. When Courtney finished, the judge took a recess before the defense even began. I walked out of the courtroom into the hallway and sat on the bench like I'd just crawled out of a trench. Courtney sat beside me. "They're done," she said. "You think so?" "I know so." She pointed toward the hallway where a local news crew was already setting up outside the courtroom doors. "Welcome to the spotlight." The second half of the hearing wasn't a defense. It was a collapse in slow motion. Drake's attorney attempted to argue that the HOA had broad authority to enforce rules, and that, while unfortunate, the situation with my son's ambulance was an unintended byproduct of neutral policy. The judge didn't even raise his eyebrows. He just asked, "Did your client authorize the towing of a medical vehicle?" The lawyer hemmed, hawed, said something about unclear delegation, and then tried to pivot. But Courtney wasn't done. She stood up and introduced the final piece of evidence, the city's official response letter, signed by a transportation officer, stating in black and white that no authorization for a tow at my address was ever issued, that the form used had never been generated by any municipal office, and that the city intended to open a separate investigation into the forgery of government documents. Drake didn't look at anyone as the judge read it aloud. That's when the bomb dropped. Courtney called a surprise witness, someone we hadn't even mentioned during initial filings, the tow truck operator. The man was big, tattooed, and clearly uncomfortable in a courtroom. But he told the truth, plain and simple. Guy in a polo handed me the form, said it was city approved, had a fake seal, and everything. I had doubts, but he told me to hurry. Pointed at the van like it was a drug bust. Courtney held up a photo from the HOA's own Facebook album, Richard Drake, in the driveway, same day, same polo. The judge looked directly at Drake. Do you have any rebuttal to the witness's statement? Drake stood up, face blotchy, voice strained. I acted in the interest of the community. That's not a rebuttal. That's a rationalization, the judge snapped. Sit down. By that afternoon, we were done. The ruling came the next morning. I was sitting at the kitchen table with Courtney and Tyler when her phone buzzed. She read the message, smiled, and turned the screen to me. Judgment in favor of plaintiff. Full damages granted, $65,000. Court fees covered. Mandatory revision of HOA policies under ADA compliance review. Drake, removed from his position by court order and referred to the district attorney for potential charges related to document forgery and obstruction of medical access. Melissa texted me before noon. They're imploding. Half the board resigned. HOA email is down. Drake's house got egged last night. I didn't respond. I was too busy getting Tyler dressed. We had somewhere to be. That afternoon, we drove to his therapy clinic, his new state-of-the-art one paid in part by the lawsuit settlement. Chris met us there, grinning ear to ear. Told you we'd bury them, he said as he helped me unload the van. Tyler didn't say anything. He never could. But he smiled. Not the confused smile of politeness, not the glazed one he gave when he was tired. A real smile, wide, crooked, tired, but his. I stood in the parking lot for a moment, just breathing. It wasn't over, not entirely. The HOA would limp on. Drake might still try to wriggle out of the charges, but something had changed. Not just in Willow Hills, in me. We weren't invisible anymore. 6 months later, Willow Hills looked the same on the outside. Same trimmed hedges, same color-coded garbage bins, same polite nods from neighbors as they walked their dogs. But underneath the surface, something fundamental had shifted. The HOA board was a skeleton crew. Half the members had resigned after the ruling, and the rest kept their heads down, issuing no new violations, holding no meetings, and responding to emails with legal disclaimers longer than actual answers. A federal ADA coordinator had been appointed to oversee the revision of all community policies. Every newsletter now came with a new disclaimer at the top. All policies must be interpreted in compliance with federal disability law. No more fines. No more threats. No more paranoia. As for Richard Drake, he was gone. Not just out of the HOA, but out of the neighborhood. Sold his house in a fire sale and moved out quietly, probably hoping no one would recognize him at the DMV when he changed his address. The DA confirmed he was under investigation for forgery and abuse of authority. I didn't need to follow up. Let the system do its job. I'd done mine. The $65,000 from the settlement had gone exactly where I said it would. I renovated Tyler's room, new lift system, better insulation, a therapy bed he actually liked. We installed a backup generator in case of emergencies. I prepaid a year's worth of private transport with Chris's company and set up a small legal fund for any future nonsense from the HOA. But the best money I spent? A sign. I had it mounted at the front gate of my driveway, where the van parks every day now without interference. Big, bold letters on brushed steel. Disability is not a choice. Cruelty is. The day it went up, Melissa stopped by. She didn't say anything, just stared at the sign for a while, then gave me a nod and walked back to her place. I think that said more than a speech ever could. Tyler's doing better. His seizures are more stable now. He's got a new therapist, one who doesn't flinch when he twitches or asks me quietly if I'm okay when he zones out. We go to the lake on weekends. We're learning to live again, not in fear, not in defense, but forward. Sometimes people ask me if I plan to move. I don't. Not because I love this place. I don't. Not yet. But because Tyler needs stability, and because leaving would feel like surrender. And I didn't claw through a wall of bureaucracy and bigotry to retreat. Some battles are worth fighting just to remind the world that people like my son aren't burdens. They're reasons.